It's Entertainment Law Update, episode number 187 for January 2026. Happy New Year. Hello, everybody. Welcome to Entertainment Law Update. From Los Angeles, California, I'm Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamera, Bennett.
And today we are recording audio only because there's been a big storm, and at least one of us is caught in the midst of it.
Yes, at least one of us is actually recording from the Nashville metropolitan area today, and
the Arctic region of Nashville.
The Arctic region, metropolitan region of Nashville. If any of it's January 28th, the big storm just came through. Fortunate I got to come stay with my mom this week while this big storm is coming through, and we can't exit the driveway. So there you go. And where I was going to go record today, which I have a wonderful co-work space that's close by, it didn't matter that I couldn't exit the driveway because they can't get to work to unlock the co-work space. So folks, it's old school. It's audio only today.
Well, we're glad that you were able to be part of it, that your electricity and heat and all those things are on, so it's all good. Well, thank you all for the audience for being with us. This is the podcast by entertainment lawyers about entertainment law, where each month we round up notable cases and news and information to keep you informed and hopefully a little bit entertained. We do welcome your feedback. We love it. So send us your suggestions and input. And you can do that by visiting entertainmentlawupdate.com, using the voice widget on the side of the screen, or just send us an email. entertainmentlawupdate@gmail.com is the place to go for that. Now, I had a busy early part of January, celebrated my big 60th birthday earlier this month, and then just a day or two later had to hop on a plane to go to Orlando for the PodFest Expo, where I've spoken, it looks like it's each of the last 10 or 11 years now. And
wow, that's great.
Yeah, I get a lot out of it. It's good for business. It's good for my soul, and I get to visit with lots of friends and like-minded folks in the online creator space, which lights me up. So that was fun, and managed to get, well, it was very cold while we were in Orlando. I've never been in Florida where it was, 40 degrees at night. So not like it is in Nashville these days, but it was still pretty interesting, and got out before the storm hit over there. So glad to be back at safely ensconced here in LA and ready to power through with things. So, you had a CLE program scheduled for sometime this month or coming
yeah,
soon.
I guess for mid-January with mylawcle.com, there were some scheduling issues, so it has been pushed back and rescheduled for February 27th. Actually, I believe it's going to be 3 different CLE presentations on that day. Myself and Jordyn Hendrix, who is an attorney with me at Harper Bates, are presenting one of my favorite topics, trademarks in the wild, real-world lessons from Rogers, Jack Daniels, and pop culture litigation. We're going to do a case law review and give some practical application of balancing trademark rights and artistic expression in the media landscape that we have today. So It's always a fun CLE to put together and present. So if folks are interested, hop over to mylawcle.com. I checked this morning. I don't see hours up yet on the website, but it should be coming soon. And if it doesn't come soon, I'll give you another update.
All right. Well, we usually record our episodes a little earlier in the month than, the last few days. So it's a little later than usual to talk about this. But as happens each new year, on January 1st, a major cohort of cultural works became a part of the public domain here in the United States, meaning that their copyrights have expired and anyone can now copy, adapt, or build on them without needing permission or having to pay royalties. And what's really special about it this year is that it's one of the largest and most sort of wide-ranging groups of works that we've seen. Big changes this year, big migration into the public domain. So that includes books and films and musical compositions, artworks, comics, and early character appearances that were first published in 1930. Among the highlights now free in the literary area, we have the first 4 of the Nancy Drew novels, Classics like The Maltese Falcon and As I Lay Dying, and in visual and entertainment culture, early appearances of characters like the original version of Betty Boop, the comic strip Blondie, and Mickey Mouse's dog Pluto. Interesting, I didn't know this was initially the name of that character was Rover, which is interesting. They have all entered the public sphere along with significant films from the early sound era and works of art from leading modernists. We'll have a further story about that in a moment. But on the musical compositions side, we have standards like George and Ira Gershwin's I Got Rhythm, Embraceable You, Hoagie Carmichael's Georgia on My Mind, all those great standards have also entered the public domain, allowing the underlying songs to be performed, arranged, and recorded freely. But sound recordings, the actual recorded performances, follow a different schedule, because historically here in the U.S., they were not covered by federal copyright until the Music Modernization Act of 2018 updated the regime for all those pre-1972 recordings. That law, the MMA, set distinct terms for those older recordings, and as a result, we're reaching back 100 years. Recordings published in 1925, such as Bessie Smith and Louis Armstrong's St. Louis Blues, Gene Austen's Yes, Sir, That's My Baby, Marian Anderson's Nobody Knows the Trouble I've Seen, all entered the public domain on January 1st, even though the same calendar year's compositions entered had a 95-year cycle. So, just, if things aren't confusing enough in the law, right?
We'll just add a little bit to it. And I will also say, and we've got a link in here that where you can look at a lot of different things that have gone into the public domain. Is it Stanford law that puts that out?
Yeah, I think so.
Maybe we don't have that link in there and we need to pop it in. But also a great resource, especially for these old sound recordings. And again, quality you need to check, and obviously you need to triple check the dates, is the Library of Congress. Their website has so much information. And again, there's a lot of things on that website that are still protected by copyright in the U.S. and around the world. I know this next story we're going to talk about talks about these issues regarding outside the U.S., but, practice pointer, please note, public domain only applies to the U.S. rights. We've got to look into the other countries to determine their scope and length of copyright term.
And we have a couple of stories in the rundown today that sort of deal with that foreign rights issues. Certainly this one, the Mondrian story. Since we're talking about public domain, I want to give a hat tip to Aaron Moss over at Copyright Lately for bringing our attention to this controversy. Piet Mondrian's 1930 painting Cosmopolitan with red, blue, and yellow, very famous, iconic work. You've seen it, I'm sure. That work entered the public domain on January 1st, along with other works from 1930. And so now it can be freely reproduced and shared and adapted without permission or payment needed. But copyright law is different in other countries, and term lengths vary based on Life Plus rules. But here in the U.S., the basis is the work was first published long enough ago that the term has expired. Nevertheless, the Mondrian Holtzman Trust has been circulating letters claiming that the work is still protected and that permission or licensing might be required, and references terms like dual copyrights and foreign law protections. And the thing is, the copyright experts and commentators say those arguments don't really match up with how U.S. copyright law actually works. There's no separate parallel term that would extend protection beyond normal dates. And this really raises the issue of, even when a work is legally in the public domain, estates and rights holders are sometimes aggressive about proposing confusing claims, discouraging people from using the work, threatening, and those kinds of things. It's this uncertainty that sort of chills creative expression, reuse, and public access and things. So, folks, when they're not sure what to do, they choose not to do. So
sure. And I think it's also another place to have a reminder here. We talked about this many episodes in years past about the Sherlock Holmes estate. And even when we talked about Nancy Drew, which, gosh, I can't believe Nancy Drew's in the public domain. It's not all of Nancy Drew because not everything was written in 1930. And then I get to thinking about, I was a huge Nancy Drew fan. And so much so that my sister made me, for Christmas, a quilted out of fabric with the Nancy Drew books and things on it,
Oh,
a
cool.
little book cover. So, but the artwork on those various books, if you're a Nancy Drew fan or a Hardy Boys fan, it changed over the years. So again, not every element of what we're talking about is in the public domain. Right. So you still just need to be really careful about that.
Yeah, and if you're going to be using works like that, or if your clients are going to be using works like that, then, the thing to do is make sure you're using the works that are in the public domain, the version, the edition of the book from 1930, not from 1938 or 45 or whatever, when they may have been reissued and things like that. So, important to just still be careful. So, let's go on to this Top Gun Maverick pair of cases that came in for pretty hard crash landings. Forgive the pun. Go ahead. You want to do this one?
Sure. Well, this is hot off the presses, or hot off the court's ruling in January 2026. The Ninth Circuit ruled in Yane versus Paramount Pictures Corp., rejecting a copyright challenge to Top Gun Maverick, the movie. A little backstory. The plaintiffs were the heirs of Ehud, is that how you say it, Yane, who wrote the 1983 California magazine article Top Guns. And that article inspired the original Top Gun film released by Paramount in 1986. Yane had assigned his rights to the article to Paramount. And when, I think article, I think like a few, maybe a 500 words, 750 words in a magazine. No, this was a multiple page article. So it did go into details about these fighter pilots. In 2020, his heirs, he had already passed away, timely served on Paramount a notice of copyright grant termination pursuant to Section 17 U.S.C. 203, which allows those heirs to terminate certain copyright grants made during the author's lifetime. Then in 2022, we have the release of the movie Top Gun Maverick. The heirs sued Paramount, alleging that Top Gun, I can't speak today, Maverick copied protectable elements of that 1983 article, as well as Paramount breached a contractual obligation for credit. And they pointed to similarities between the 1983 article and the 2002 Top Gun Maverick movie, such as elite Navy pilots, the training culture and camaraderie between those pilots, their dialogue style, themes, aviation details. I assume there are people in the world who haven't seen either Top Gun or Top Gun Maverick, but it's hard also for me to imagine the first one came out in 1986. Right. But we've had 40 years of Maverick. And I do, anyway, I watched Top Gun Maverick, and of course it evoked the original Top Gun movie. And there were things that obviously with characters and actors that made me invoke the original movie. I've never read the article. The trial court in the Central District of California granted summary judgment for Paramount. They found no substantial similarity in protected expression, and they excluded the plaintiff's expert for failing to separate facts from expression. That was at the district court level. On appeal, the Ninth Circuit affirmed that ruling. They applied the Supreme Court opinion from 1991, Feist v. Rural Telephone. The court emphasized that copyright protects original expression, not facts. Real-world elements, the Top Gun school, pilot culture, how they train, aircraft design, are free for all to use. The court also relied on the recent Ninth Circuit 2020 opinion of Skidmore v. Led Zeppelin, stressing that courts must filter out unprotectable elements before comparing the works. Because the alleged similarities operated at a high level of abstraction, ideas not protected by copyright, themes, genre, the court held there was no infringement, memorably concluding that, quote, what is protected is not similar, and what is similar is not protected.
Yeah.
Interesting quote. Close quote.
Yeah. Makes me wonder, actually, if the original movie really needed the rights from the article, or, that inspiration didn't mean that the article had the same storylines about characters with, deceased fathers who were Navy fighter pilots, and the relationships between pilots and their Rios, and all those kinds of things that are really at the core of the movie Top Gun. I suspect there were the inspiration, but not the actual material. So, and if you look at that list of the similarities that they pointed to, the elite Navy pilots, training culture, camaraderie, dialogue style, themes, and even aviation detail, none of those are protectable elements. Those are all idea or fact kinds of things.
Sure. And I'm pretty sure this is where we landed on it when we've discussed this in the past, is that question of how much was really a derivative work of the article, or was it more about actually the production company, in my mind, kind of doing the right thing and saying, we're going to acquire these rights and we're going to give you executive credit or whatever credit he received.
Yeah.
But it really was a very narrow scope of rights.
Yeah. And sometimes it's just more expedient to buy the rights than worry about it later, So that's one thing. There was another Top Gun Maverick case that was listed, but that we didn't actually get a summary from our team for. But I want to just share what I recall about it. It was a claim that someone, a brother, a cousin, something, I don't remember the name, of one of the writing team on the film, actually had contributed some written components of the film's screenplay. And there was sort of no real documentation of that fact, and no copyright registration, those kinds of things. So it was thrown out very quickly, but there was this other claim that kind of came at Paramount over that movie as well. And it was also thrown out just earlier this month. So anyway.
Okay. And I am kind of surprised at myself that I haven't tried to go read that original article. So that's on my list.
Yeah, exactly. If you
it's on my list. But I'll try and verify before I send any links that, it's a,
okay.
It's actually a legit link.
Well, we've talked about this case quite a lot. It's been going for, I think, over a decade now, but the Queen Anne's Revenge is having further revenge, and the case has again been scuttled, to use maritime terminology. The case is Allen versus Stein, and now we have an opinion from the Fourth Circuit from just a few days ago, January 23rd. Videographer Frederick Rick Allen and his company Nautilus Productions were originally hired as the exclusive videographer to document the excavation and recovery of the pirate ship, the Blackbeard ship Queen Anne's Revenge, which was off the coast of North Carolina. Nautilus spent nearly 2 decades capturing video of the state-sponsored salvage and recovery operation, and then registered copyrights in all of that footage. And in 2013, Allen discovered that the state of North Carolina was using the footage without permission. And then the state he alleged that the state infringed his copyrights by using that content without permission, and then passing a state law that arguably authorized that use. Interesting. So first, the district court dismissed a bunch of the claims, but did allow Allen's declaratory judgment and copyright infringement claims against the state to proceed, concluding that Congress had validly waived state sovereign immunity under a law called the Copyright Remedy Clarification Act, CRCA. On the first appeal, a number of years ago now, the Fourth Circuit rejected that, and the Supreme Court then affirmed the Fourth Circuit's ruling and declared that sovereign immunity did protect the state from Allen's copyright claims in this instance. Well, after those rulings and a dismissal of his other claims against the non-governmental defendants, Allen tried again in 2021 to reopen the case in district court. He asserted a new constitutional theory that sovereign immunity could be abrogated on an as-applied basis under a case called United States versus Georgia, which raised a 14th Amendment, I guess a sort of due process kind of an argument. The district court allowed amendment of the complaint under Rule 54B, and in 2024, again denied sovereign immunity on that basis, letting the Georgia-based claim proceed. North Carolina appealed both the reopening and the denial of sovereign immunity, and now the Fourth Circuit has held that the district court abused its discretion by using Rule 54B to reopen the litigation in the absence of extraordinary circumstances to justify that. And the thinking here was that the Georgia case actually predated this case, but it was never pleaded until after the Supreme Court had already ruled on things. Rule 60B would have been the proper vehicle, but it wasn't supported here. And because the reopening was improper, the appellate court reversed that order, vacated the 2024 ruling as moot, and remanded with instructions to close the litigation and dismiss all claims against the state defendants with prejudice. So that feels like it's the real official last-ditch end of things, but he might have a basis to appeal. I don't know. The Supreme Court has already ruled on the case. It seems unlikely. So that's where we are.
Well, we always appreciate Mr. Allen for keeping us updated and sending us links as the case has proceeded over the last decade.
Yes. So a shout out to Rick, who is I guess a listener and follower of the show. We appreciate it, and we're sorry that things didn't go your way. But anyway, we're glad we're able to share the outcomes with folks.
Yeah.
Okay.
It's interesting and scary.
Yeah. Well, here's an interesting and odd, unusual, because it's the only jurisdiction that has come this way. A Fifth Circuit case. You want to talk about Vedder versus Resnick?
Yeah, Vedder versus Resnick. We discussed it a year ago.
Yeah.
Big picture, Cyril E. Vedder and Vedder Communications Corporation, the Vedder plaintiffs, brought a lawsuit against Robert Resnick and Resnick Music Group, collectively Resnick. Vedder was seeking a declaration that they are the sole owners of the copyright rights to the song Double Shot of My Baby's Love throughout the world. Vedder and Donald Smith wrote Double Shot. Vedder assigned his copyright rights to that song to a music publisher, and years later terminated the assignment and recaptured his rights. Co-writer Smith died. Vedder Communications purchased the renewal rights held by his heirs. The Vedder plaintiffs filed a complaint in the Middle District of Louisiana alleging that they are the exclusive owners of the copyright rights to the song Double Shot and that they may exploit those rights in the United States and abroad. On a year ago, January 29th, 2025, the district court denied Resnick's motion to dismiss and granted the Vedder plaintiffs' motion for summary judgment. The district court declared the Vedder plaintiffs to be the sole owners of the copyright rights to Double Shot throughout the world. Resnick appeals. 1 year later, almost to the day, January 12th, 2026, the Fifth Circuit affirmed the district court's judgment in full, stating the district court's declaration is supported by statutory text, context, and purpose. Kind of a quick timeline. That was the big picture. 1962, Vedder and Smith co-write Double Shot of My Baby's Love. They assigned their rights to Windsong Music Publisher. And Windsong acquires all the rights in the musical composition for both the initial term and a contingency interest in the renewal term. This is under the Copyright Act of 1909, where we had two terms. Windsong registers the copyright in 1966. Unfortunately, in 1972, Don Smith passes away because he did not survive to the start of the renewal term. His heirs claimed that renewal right in 1994. After the original copyright term ends, Smith's heirs and Vedder again retain that copyright with 50% held by Windsong and the Smith heirs holding the remaining 50%. Over time, there's an assignment to which Vedder acquires the 50% interest from his co-writer's heirs. Windsong continues to own that other 50%. By the time everything is all said and done on ownership, Vedder holds 50% of the renewal copyright interest. Two other publishing companies own 25% equally. In 2019, Vedder, again, he already owns 50%. He issues a termination notice to reclaim his songwriter author interest. And now that percentage was owned by Robert Resnick. That's where the Windsong interest ended up landing. So anyway, he follows the procedure. There's no question. The court makes it clear there's no factual question as to the, I guess, the validity and process of this termination notice and the procedure. There's no factual issues. May 3rd, 2022, Vedder recaptures this authorship copyright share, at which point Vedder asserts and believes that he and his entity control 100% of the copyright throughout the world. Kind of a triggering event that leads to this deck action is in that 2022, ABC, who already had certain rights in the song for an audiovisual work, approached Vedder requesting an expanded license for a grant of rights. Vedder states that he and his corporation are the sole owners of the copyright throughout the world, and I guess proceeds to issue the license. Then in 2023, Vedder sought a deck action regarding that ownership of 100% of the worldwide rights in Double Shot.
That makes me think that something must have happened there after.
Yeah, there had to have been a nut. There was something going on there that there was a dispute over those rights in that license request that kind of triggered all of this moving forward. And as I said in the kind of the big picture in 2025, summary judgment was entered in favor of Vedder and Vedder Communications Corporation, holding that the copyright grant termination notice was not just for the United States, which is, to my knowledge, how every other court prior to this decision has treated that, but it actually terminated rights worldwide. On appeal, Resnick argues that the district court erred by declaring Vedder to be the sole owner of the Double Shot copyright throughout the world in relationship to Vedder's recaptured copyright interest. They looked at three main reasons, and we'll kind of walk through those. One, Resnick argues that Vedder's notice of termination does not affect foreign rights based on the plain language of the statute, 17 U.S.C. 304C. Because it says the termination provision is limited to and, quote, in no way affects rights arising under other federal, state, or foreign laws. The court, this is fun. If you have studied legislation, legislative history, I was texting Gordon while I'm on the airplane reading this case for like the second time, going, what's the order of review of secondary sources? Because the court relied on definitions, plain language, legislative history. So anyway, it's an interesting read from that standpoint. But the court determined that the statutory text and context supported that terminations are, quote, worldwide, as under the copyright statute. The rights originated from the Copyright Act, and so was effective as to all of his rights without a specific geographical limitation. They said this was supported by the Kurtzing case, which we discussed a lot in previous episodes, involving first sale doctrine being applied to international purchase and sale, in that case of books, saying, well, because of the decision on that, favors a non-geographical interpretation of this provision. It looked at statutory purpose. The court deemed that only allowing terminations to cover U.S.-based rights would leave authors with half the apple. If you go read the legislative history related to the insertion of the termination of copyright grants, there's a lot of talk about the authors and creators getting another bite at the apple to renegotiate a bad deal they may have had years ago. So that's kind of that half of the apple. Yeah. Part two, they said it contradicts case law. I'm going to tell you what the court said. I don't know that it contradicts case law, but I'm not the judge here. Resnick contends that the district court's interpretation of the statute contradicts case law on the statutory termination of foreign rights. The court looked at Siegel versus Warner Brothers, big copyright termination case, a case where the widow and daughter of Jerome Siegel, a co-creator of Superman, failed to terminate rights worldwide. The court stated that that was an out-of-circuit case, and it relies too heavily on the treatise Nimmer and Patreon copyright law. I've never heard a court say that, but okay, those are secondary sources. The court also evaluated Clancy versus Jack Ryan Enterprises, where the surviving spouse of the author, Tom Clancy Jr., concerning rights to the character of Jack Ryan. The court said that's an unpublished opinion that also relied on the Siegel v. Warner Brothers and relies on Nimmer. So we're not bound by following that. The final case was Fred Allhart Music Corp versus Warner Chappell, and it was the only case the court deemed they could support Resnick's argument, but the decision itself did not consider a geographic scope of termination. Then they looked at conflicts with U.S. obligation under foreign treaties, again, saying, well, if you do this, it's going to expand the rights Americans have beyond the rights of other citizens of the world and other countries under Berne and the Copyright Convention members. And the court analysis is a little different, saying Berne simply means that all countries must acknowledge foreign copyrights as valid, rather than creating and being a part of a bundle of rights. That was a mouthful.
Yeah.
So, go ahead.
I was going to say, it actually sounds like the argument goes the other way, that by establishing, at least in the eyes of the court, what they're doing is bringing American copyrights sort of in line and equal with foreign copyrights. I'm sorry, the rights of authors sort of equal with those of foreign authors. You get what your country's law provides.
Yeah, I think that, the argument, what the court ruled is to say, if you have copyright protection under the U.S. copyright law, which is, this is interesting because,
yeah, it covers the whole copyright.
When you terminate these rights, you reclaim everything you granted. If you granted the copyright for worldwide rights, then you should reclaim worldwide rights. Yeah. Now, again, I'm unaware. I think you are unaware. I'm pretty sure we're correct in this, that there are no other cases in the U.S. that have ruled and made this holding.
Right. That's my understanding. It's
right. And that everyone else, this is the Fifth Circuit case. The whole time I've functioned in the world of copyright and the music business, it's always been an understanding that the termination was for U.S. rights only.
Right. Interesting. Obviously, lawyers in the entertainment industry are going to have clients on both sides of these issues. I know you do. I know I do. And it really, I'm torn. It really is. I've read it 3 times. I need to read it again. I apologize. I probably didn't we're giving highlights here. We've got some
on the summary
notes that are of some very interesting analyses of these. And there's lots of it out there. I know a lot of the copyright commentators have weighed in, and this is a very controversial decision. The real question is, does a foreign court if you terminated a worldwide transfer, or maybe it's just a foreign transfer of foreign rights under U.S. law, does the foreign publisher or whoever the assignee or purchaser of those rights is, what if they don't comply? Then you got to go sue them in their home country and see if
right. Yeah. So, I kind of just the notes that were kind of running through my brain. Well, one, it's a Fifth Circuit. So obviously the Fifth Circuit has said clearly they don't have to follow I can't remember if the
second
Siegel
or ninth
case
or
is
whatever it was.
second or ninth circuit, which are going to be the two circuits where these big cases are coming out of, and that's true. They don't have to follow.
Yeah.
It's not a precedent. I'm asking myself, because this is under Section 203 of the 17 USC and not Section 304 of 17 USC. Does this only apply to copy grant terminations pursuant to the 1909 Act two-term system? Or does it apply to 203 terminations under the U.S. single-term copyright? I don't know.
Well, from a practical
what do you think?
Same question. There are a couple of foreign court decisions. There was a Duran case. There was another one involving Ennio Morricone music that determined that contracts and disputes would be governed by, in that case, in the Morricone case, it was Italian law, although the U.S. copyright rights were governed by U.S. law. The U.K. court in the Duran case, similar, wouldn't allow the songwriters to recapture their U.S. copyright rights under I guess it's the same section.
So they were actually, that was under for Marconi. It may have, I don't know which, but for Duran, it was under the Section 304.
Okay. Yeah.
Because it was a 35-year. Because the contracts for Duran was a UK contract, they brought suit in UK court, and then they said UK contracts control. And then in Marconi, it was Italian law, Italian contracts, but they brought suit in the US.
Well, I think as a practical matter, what we can expect to see is certainly foreign acquirers of rights to fight harder to have jurisdiction and venue under their law rather than U.S. law. And even in the U.S., probably do everything you can to keep things out of the Fifth Circuit if you're a publisher or a buyer.
Yeah, and because of that narrow scope of the Fifth Circuit, Texas, Louisiana, Mississippi.
I think so.
Sorry, Fifth Circuit people. I'm only remembering Texas and Louisiana. It's not Tennessee. It's not New York, and it's not California, which are going to be a bulk of the contractual
choice of law provisions. Yeah.
Choice of law.
Yeah, I mean, it doesn't seem like there's that many. Well, there may be lots of rights holders in the Fifth Circuit, but I don't think there's that many of the major players in the industry, company-wise, that are domiciled in those states. So,
yeah. So, I mean, both sides of the coin. One, representing authors, this is a win.
Yeah.
We need to figure out how to enforce this and make it work. Representing the assignee, the book publisher, the production company, whoever acquired those rights, on that side of it, we got to really figure out how far does this apply.
Yeah.
So anyway, it's there. We gotta be aware of it. Some really great articles. I actually put in a link of a paper that goes into the Duran and Morricone cases, because the paper was written in 2020. So obviously predates this decision, but very scholarly, very well thought through, to kind of really take a look at the this interplay between foreign laws and U.S. laws when it comes to the rights of copyright and whether who controls it. Yeah. So it's an interesting question. And we started this conversation talking about public domain and saying, but that public domain only applies to the U.S. rights. So how are we going to be slicing and dicing this when it comes to copyright?
Yeah, I mean, if the rights originate, according to this logic, if the rights originated under U.S. law, then it's public domain everywhere. The moment it's public domain here, that may or may not be an outcome we want to see. Do you think the Supreme Court will weigh in on this case? I mean, is there...
Well, I mean, I guess we have
sort of a split of authority.
Do we have a split in circuits?
Well, it certainly creates the kind of uncertainty that a split creates. So maybe.
I mean, I guess we kind of thought, or I thought that the Raging Bull case.
Yeah.
I can't think of the
I'm
citation.
blanking on it too. Yeah.
I mean, I remember at times thinking they're not going to hear that case.
Right. Right.
But they did. And they made copyright law. They made precedential law for us. So,
yes, well, we'll see. We got a little time. We'll find out if there's an appeal, if there's a petition filed, and then we'll see. So,
yep.
Well, while we're talking about termination rights, this is a related subject. Salt and Peppa, the hip hop group, They push it, but they get pushed back. The case is titled James versus UMG Recordings. It's in the Southern District of New York. It was decided on the 8th of January. Salt and Peppa, as you probably know, are pioneers of hip-hop. They were formed in New York in the mid-'80s by Cheryl Salt James and Sandra Peppa Denton and DJ Spinderella. They were among the first women to break through to mainstream success in rap. And they didn't have just hits, but they changed the entire culture. Their songs like Push It, Shoop, What a Man, Let's Talk About Sex all dominated radio, MTV, and pop culture, while putting women's voices front and center in the genre. In May 2025, they filed a lawsuit against Universal Music Group in federal court in New York, asserting that the label had unlawfully refused to return the copyrights and physical master recordings for their early catalog of hits. The duo based their claim on Section 203, same one we were talking about before, a provision that allows artists to terminate their grants after 35 years following a transfer under certain conditions. They said they served valid notices in 2022 and that UMG has refused to honor those notices and that its decision to remove their music from streaming services has effectively blocked their ability to control and profit from their own recordings. So UMG files a motion to dismiss, arguing that the group had never actually owned the copyrights to begin with and therefore had nothing to terminate. And central to this were a series of contracts in the 80s, 1986 in particular. Salt and Peppa signed a recording deal with Noise in the Attic Productions that was run by their producer. The same day that Noise in the Attic entered a distribution agreement with Next Plateau Records. And the judge looked at everything and found that the agreements explicitly gave ownership of the sound recordings and copyrights to Noise in the Attic and then to Next Plateau, not to the artists themselves, meaning that the group never executed a qualifying copyright transfer that could be terminated under the statute. Now, what's interesting is that the court suggested that the language in the original recording agreement was consistent with work-for-hire treatment. I don't know what that means. Either it's a work-for-hire clause or it isn't. But anyway, and they noted that the recordings were registered as works for hire and that the contract gave exclusive ownership to the label-related entities. But the judge didn't base the dismissal on a formal finding that they were works for hire under the statute's definition.
Well, and sound recordings aren't specifically enumerated.
Oh, that's right. Okay. That explains that.
So, well, maybe unless they were trying to claim they were an employee and done within the scope of their employment. Yeah. Anyway, sidebar.
Well, right. Anyway, so the court grants the motion and dismisses the lawsuit in full. The judge, Judge Coate, held that because Salt and Peppa couldn't possibly argue that they had ever held the copyrights they sought to reclaim, the declaratory relief claim has to be dismissed. And the court also rejected related conversion claims regarding interference with their master tapes, citing, again, insufficient evidence of ownership. So Salt and Peppa have signaled they intend to appeal, and the broader debate over termination rights and artist ownership will continue. So,
yeah. And a couple of cases that folks may want to go read related to loan out companies and copyright grant termination, the John Waite versus UMG class action, 2019, 2020. I'm not sure on the year of that. And then we talked about a couple of times over the past years, the Bad Boys versus Columbia Pictures. And that case was settled. So we don't have a ruling, but it was, I believe, an issue regarding the production company being a loan out and, who actually conveyed the rights to Columbia Pictures when it came to that copyright.
Well, Yeah, I mean, what you said about sound recordings reminds me, and it makes it, they're not eligible to be works for hire. So that's why the court doesn't address it. That makes better sense in my mind than I was just vacant on that for a minute. All right. Well, let's talk about this next case. This is more on Mariah Carey and All I Want for Christmas. You want to handle this one or shall I?
Yeah.
Go for it.
Well, there's some money involved in this one. Andy Stone, professionally known as Vince Vance, we've covered this case in years past, sued Mariah Carey along with co-defendants Sony Music Entertainment, Cobalt Music Group, and producer Walter, my best guess, Afanasieff, in the U.S. District Court for the Central District of California. The nature of the lawsuit: Stone filed suit in November 2023, alleging that Carey's 1994 holiday hit "All I Want for Christmas Is You" infringed his 1988 country song with the same title. He claimed Carey copied protectical lyric and musical elements and sought approximately $20 million in damages. The defendants denied infringement, arguing the song title is not copyrightable. The alleged similarities involved generic Christmas themes and common lyrical phrases. The two compositions were structurally and melodically distinct. They also challenged the evidentiary foundation of Stone's experts' analysis. In 2025, the district court dismissed the lawsuit in full, finding that Stone failed to produce sufficient evidence to support his claim of copyright infringement. And the court later granted attorney's fees and sanctions, ordering Stone to pay nearly $110,000, including more than $92,000 to Carey. Issues and legal reasoning to the case: the central legal issue was whether the alleged similarities involved protectable expression under copyright law. That sounds reminiscent of what we just talked about in Top Gun. And the court held they did not. They relied on Ninth Circuit precedent, the Skidmore case we also talked about, emphasizing that common phrases, ideas, and themes, especially in a genre like Christmas music, are not protectable. The similarity must exist in original elements, not stock concepts or scenes of fare. And the plaintiffs must present admissible, non-speculative evidence, particularly when relying on expert testimony. The court found that Stone's claims relied on generalized similarities. There was no showing of concrete copying. Again, there was something going on with the expert analysis.
The judge come into my court and guess is what the judge is saying.
Yeah, that's right. The judge went further, characterizing the plaintiff's litigation conduct as egregious. Wow. She cited baseless legal arguments, unsupported facts, counsel's failure to adequately address the interest of a co-writer in the song, or I guess his interest in his co-writer. The court concluded that the defendants were forced to incur unnecessary cost, ordered fee shifting, sanctions of over $109,000, $92,000 plus to Carey herself, the rest to be divided amongst the other defendants in the case. The court also asked, and this is the one we don't like to hear, they asked his attorney to explain why disciplinary action should not be imposed, signaling potential ethical concerns beyond the merits of the copyright claim itself.
Interesting.
Yeah.
That's, I don't know if Carey's team or one of the defense briefs mentioned and asked for sanctions as a remedy, but certainly seems to be, if the court's doing that on its own initiative, that's pretty wild, pretty big. So,
yeah. So anyway, general expressive ideas are not protectable. It's the expression of those ideas. And there just wasn't substantial similarity.
Yeah. Well, we also have the case of Sedlick versus von Drakenberg. That's a Ninth Circuit case decided earlier this month. The plaintiff is Jeffrey B. Sedlick, the professional photographer who owns copyright to that iconic 1989 photo of Miles Davis. The image was properly registered with the U.S. Copyright Office, and the defendant is Catherine von Drakenberg, professionally known as Kat Von D, the tattoo artist, and her tattoo business, High Voltage Tattoo Inc. She's a well-known artist whose work frequently attracts public attention on social media. And so we've talked about this case before. The lawsuit arose when she tattooed a likeness of Miles Davis onto a client's arm and used a digital copy of the Sedlick photograph as a reference. She also created a preparatory sketch and posted several images online, including photos in progress of the tattoo being done in progress and the reference photo visible in the image next to it. So when Sedlick discovered the tattoo, he contacted von Drakenberg asking for a license fee, and those discussions failed. So he filed a suit in federal court for copyright infringement. He alleged that she unlawfully copied protected elements of his photograph in multiple ways: by creating the tattoo itself, by producing a sketch derived from the photograph, and by publicly displaying images related to the tattoo process and social media. Defendants didn't seriously dispute that he owned a valid copyright or that his image had been used as a reference. They focused on the limits of copyright itself. She argued that most of the challenged works, the tattoo, the sketch, and several social media posts were substantially similar to the photo in copyright terms. As for the few images that were substantially similar, specifically process images showing the photo being used during the tattooing process, they claimed fair use. So, on substantial similarity, the plaintiff has to prove not only copying, but unlawful appropriation. The Ninth Circuit requires proof of substantial similarity, and uses a two-part test: the extrinsic test, an objective comparison of specific protectable elements like composition, lighting, pose, those kinds of things. And then the intrinsic test, which is a subjective assessment of whether an ordinary reasonable observer would perceive the two works as having a similar total concept and feel. And you have to satisfy both of those for there to be infringement under the Ninth Circuit rules. So the case proceeded to jury trial in federal district court. And after expert testimony, viewing the works side by side, and receiving detailed instruction on copyright law, the jury reached a nuanced verdict. It found that 6 of the challenged works, including the tattoo itself and the sketch, were not substantially similar to Sedlick's photo. And it found that 4 process images were substantially similar, but concluded that those images constituted fair use. So judgment was entered for the defendants on that verdict, and Sedlick filed a post-trial motion for judgment as a matter of law, Rule 50B motion, arguing that no reasonable jury could have found a lack of substantial similarity, and the court denied that motion. So here we are on appeal. Sedlick challenged the district court's earlier denial of summary judgment, and the Ninth Circuit rejected this not on copyright, but on procedural basis. Relying on the Supreme Court's decision in Ortiz versus Jordyn, the court emphasized that generally the denial of a motion for summary judgment is not reviewable on appeal from the final judgment after there's been a full trial on the merits. In other words, once a case has been fully tried, the verdict rests on a complete evidentiary record, not the limited snapshot that would have been presented during summary judgment motion. So that was off the table. Next up was the jury's verdict legally defensible, the 50B motion. Sedlick would have had to show that the evidence permitted only one reasonable conclusion, and the jury's verdict on lack of substantial similarity was irrational. The Ninth Circuit Court said he failed to meet that standard. On the intrinsic test and the role of the jury, the court focused primarily on intrinsic, which evaluates similarity from the perspective of the ordinary observer. Quoting its own precedent, the court emphasized that the intrinsic test for substantial similarity is uniquely suited for determination by the trier of fact. Okay? That goes back to the origin of this two-part test, Sid and Marty Krofft Television Productions versus McDonald's Corporation. That was the H.R. Pufnstuf case. And that has been reaffirmed repeatedly, including in Gray versus Hudson and Three Boys Music versus Bolton. Because the intrinsic test turns on this subjective perception, appellate courts are reluctant to reverse a jury's application. Makes sense. So using that standard, the Ninth Circuit concluded that the jury could reasonably find that even if the tattoo was inspired by Sedlick's photo, the overall feel of that tattoo as rendered on human skin and altered through artistic interpretation differed sufficiently to avoid intrinsic similarity. So that seems to be saying change the medium and make a few tweaks and you're good. Now, the court said, look, we decline to disturb the jury's implicit findings as they pertain to the intrinsic test. Fair enough. Then Sedlick goes to the extrinsic test. He had argued that the objective similarities were so overwhelming that the court should find infringement as a matter of law, and cited the Unicolors versus Urban Outfitters case. Ninth Circuit rejected that argument on two grounds. First, that Unicolors was a summary judgment, not a jury verdict after a trial. And second, that Ninth Circuit law is clear that both the intrinsic and extrinsic similarity are required, and cited a case called Cavalier versus Random House that said, if intrinsic similarity is lacking, we need not reach the extrinsic test. Because the jury found no intrinsic similarity for most works, the inquiry ended there. So, final judgment. Ninth Circuit affirms the judgment in full, jury's verdict stands, and that's that. Now, there were a couple of concurrences in the case. Two of the judges Kim Wardlaw and Anthony Johnstone, wrote separate concurring opinions questioning the validity of the intrinsic total concept and field test itself. They both agreed with the outcome under existing precedent, but warned that the test has become fundamentally flawed and criticized it as unmoored from the core principles of copyright law. Judge Wardlaw suggested dispensing with it entirely, arguing that it invites juries to base decisions on vague vibes rather than clear comparison of protectable elements. And Johnstone traced the test's doctrinal shift over decades, cautioning that it allows juries to reach inconsistent outcomes without meaningful appellate review. So these concurrences signal a possible push for an en banc review or a reform of how the Ninth Circuit assesses substantial similarity going forward. So,
yeah. And so they never had to reach a fair use question because they said there was no substantial similarity as to the bulk of those. Well, I guess under both tests, everything, there was no substantial similarity. That is extremely interesting because you think, okay, if you take this one image and that's the only image you use, or do you take, we don't know, did they take multiple different images, take from their memory what he looks like?
Yeah. Anytime it's a purely subjective component of a test, you have to wonder about these things.
Yeah, because I guess my brain was, skipping ahead to that fair use analysis and thinking, let's say they'd reached a different outcome, said, yes, there is substantial similarity. And then we went through those fair use factors, or the defense did. If it was one tattoo on one person, what I think they're probably going to win on fair use.
Okay. That's interesting. I feel like this dicta about, only it just needs to be different enough, which is not the law, as far as I know.
Right.
But, the jury looks at it and says, well, it's different here, it's different there, it's not a copy. And here, the problem is that basically there's no appeal for that because it's a purely subjective determination by a jury.
Analysis, yeah.
Yeah. So I'm troubled still by this case, but for now, it's what we've got. So
yeah. Well, all right.
Yeah. This was an interesting story. This popped up while I was at the conference, and I was talking about Trademark as a form of protecting things, and we were talking about the right of publicity as well. And this came up in a conversation. So do you want to do it? Yeah, go ahead.
Yeah, I didn't exactly say it with the right intonation.
All right.
That was much closer to Matthew McConaughey, who has registered 8 trademarks in the name of his company, JK Living Brands, Inc., supposedly marking the first time an actor has attempted to use trademark law to protect their likeness from AI misuse. This move comes as AI-generated video, audio, and images around celebrities obviously it's everywhere. It's rising. It's rampant. with the attempt to assure McConaughey's ownership of his own voice as he ventures into his own AI business opportunities. He has registered, and again, these were filed and registered, a sound mark of audio of him saying, "All right, all right, all right," in his memorable line from Dazed and Confused, the comedy movie of 1993. Other trademarks include a 7-second video clip of him standing on a porch, a 3-second clip of him sitting in front of a Christmas tree, and an audio file of him saying, "Just keep living, right?" Followed by a pause. Then, I mean, what are we going to do? So anyway, these clips of kind of iconic phrases that are associated with him. So this is where I'm going to interject and apologize to our listeners to say, I didn't go look, I haven't looked yet to see what he filed as the specimen of use for these. Because a single phrase alone does not garner trademark right. So I am curious to see how they supported the trademark claim. But anyway, the registrations have issued.
Well, I was wondering
for
what
the
class they're in. Did you notice that? Probably 41, but
I would assume 41,
what
but we'll go.
performances by celebrities?
Maybe the mark consists of a man saying it, whereas the first syllable is at a lower pitch than the second syllable, and so on and so forth. So obviously, it's in the intonation and structure of how he says that. They applied for these marks in 2023. They were just issued in December 2025. State rights of publicity law. Again, we've discussed this. There's no federal right of publicity. Protect actors and other celebrities from having their image or likeness used for commercial purposes. However, the Jorn Levin legal team pursued the novel trademark strategy. So this is his attorneys. So McConaughey has standing to sue in U.S. federal courts in the event of infringement. The goal is deterring misuse, making people think twice, obviously. Yeah. And in addition to giving him the ability to monetize his own name, image, and likeness in AI, McConaughey is an investor in 11 Labs, an AI voice company. Since trademarks have been granted, McConaughey has announced a partnership with 11 Labs to replicate a version of his new lyrics of Living in Spanish with the likeness of his voice. So, yeah, we'll see. Is this a trend, and is this something we need to? How do we need to advise our clients about this?
Well, that's a good question. A couple of the other big talent agencies have sort of announced that they're going to follow suit and do the same with some of their big celebrity clients. And it'll be interesting to see, whether the enforcement actually works. It's certainly interesting public relations. It's certainly interesting as a potential just deterrent to companies or advertisers that might want to use these kinds of tools. I don't know that there's much. I mean, does it put a stop to any non-commercial uses of these kinds of clips and things?
I don't know. So I pulled up all right, all right, all right. It's registered as a sensory mark.
Interesting.
In class, let's see, expand all. In class 9.
Okay.
For downloadable audio-visual media content.
Oh, okay.
Video recordings in the field of self-help, human growth, spirituality. Audio, video recordings in the field of entertainment, featuring television series, comedies, and dramas, claiming a first use of January 23rd, 2025.
Interesting.
So they're not going all the way back. They're not claiming a first use back to the original movie, which makes sense,
right?
Because that would not be.
Okay, so if you were to use one of these AI tools to output a similar, an audio or a video creation of that output would be a downloadable thing. So he could then go after the end user, yes, but also the company that runs the AI that generates it, because it made a downloadable thing.
Well, this is interesting. So they filed it as a 1B, which means an intent to use.
Yeah.
Okay, here we go. Specimen. They did file a statement of use, and it is a YouTube video of McConaughey where he must be saying the phrase in connection with the goods listed.
That's interesting.
But obviously, if it's a YouTube video, that may or may not be downloadable, which is also interesting.
Yeah.
I would never submit a YouTube video for a Class 9. I would only submit that for I would only submit that for 41. But then maybe they submitted something else in addition.
I guess on YouTube, if you pay for the premium, there is a download option.
Sure.
On the menu, so they may have just been able.
And they do actually. Yeah. Excuse me. I apologize to the attorneys. When they took the screenshot, they had the pop-up popped up where you can click download. So I apologize, fellow
Which is interesting because
lawyers.
It's not really a download it's downloaded in the YouTube app, but it isn't something you can access separately on the computer where you downloaded it. So that's kind of peculiar, but it still apparently worked. So anyway,
and I mean I think it's an interesting dynamic to consider for our clients.
Yeah, definitely. I mean, certainly something we ought to take a good look at for our clients that are, achieving a certain level of celebrity at the very least. So anyway, well, I'm looking at the clock and I'm realizing we've been going for over an hour already, and we've still got a fair bit of rundown to cover. But I think we've hit the big one. So let's just cover a couple of the sort of quick takes we had here for the end. First off, we'll come up to the California modifications to its name, image, and likeness rules, its right of publicity law. The state has now updated its right of publicity law to explicitly include, and this is related, digital replicas of a person's image, likeness, or voice. So this law, SB 683, Senate Bill 683, was signed into law by Governor Newsom back in October to take effect now in January. It amends the Civil Code, Section 3344, which is the right of publicity statute, and provides for some more concrete remedies like TROs and preliminary injunctions with a very short 2-day compliance period when a court orders something being taken down. That gives rights holders more practical, fast ways to stop an ongoing misuse while a case proceeds. And, specifically calling out the digital replicas. And, so, opponents are obviously concerned about prior restraints and First Amendment and due process and things. But the feeling seems to be you'll get a hearing pretty quickly also. And, the balance of hardships thing works out. Judges are going to apply traditional standards for granting injunctions anyway. And so there's the protection there. So watch out for digital replicas if you're doing things in California, I guess. And then we have,
well, I think everywhere, because we have that in we have a version of that in Texas as well.
Yeah. And then we have the Visual Artists Copyright Reform Act of 2025. The Congress is considering this new bill called VACRA, Visual Artists Copyright Reform Act, aimed squarely at fixing a long-standing problem for photographers, illustrators, and other visual artists. Under current law, registering large numbers of images is expensive, time-consuming, and often impractical, which means many artists technically own copyrights but can't really enforce them until they register. The law would modernize the system by making registration simpler and cheaper. It would allow broader group registrations. It would reduce deposit requirements and let artists submit electronic copies instead of physical materials. It also opens the door to new tools like third-party digital registries and subscription-style filing options, so creators who produce large volumes of work aren't forced to register things one image at a time. Supporters say this is about closing the gap between copyright on paper and copyright in the real world. If artists can't afford to register the work, then they sort of lose access to statutory damages and attorney's fees, and that makes enforcement unrealistic. So it's still in the early stages, not yet a law, but if it passes, it could significantly strengthen copyright protection for visual artists in this digital age. So call your congresspeople and let them know what you think about something like this. We've got links to the bill and a sort of one-pager about it as well. So do your part and contribute your thoughts. My only thought is I wish it covered other kinds of works than visual. There's the podcaster is sort of, one that I think about. You put out an episode every week. That's 50 filing fees, 52 filing fees over the course of a year at $50 each or whatever it is, $60, I think it is. It adds up. It's hard for folks to justify filing a copyright registration for every episode. It'd be nice if they could do it as a folio of works like you can for other kinds. But once they're published, it's no longer eligible for the group registration.
That's right. So then the question becomes, if you do not allow your podcast to be downloaded,
does that constitute a publication?
Is streaming alone publication? That's a whole nother conversation for another day.
The subject of debate, too.
Yeah, that's right. So we do have, the Copyright Office and the Trademark Office put out great resources. Mm-hmm. One of the ones we wanted to point out coming up next week on February 4th at 1 p.m. Eastern is an online event that you can register to attend. It is, what is the name of this? Lights, Camera, Action, Copyright Essentials for Filmmakers. I think that's great for filmmakers, production companies, attorneys. Go listen in. And I believe if you sign up for it, even if you don't watch it live, you'll then be able to get the link to watch a replay of it. So I have found those over the years, a variety of different things to be super helpful. Even as a practitioner, sometimes it's just really good information on how things work.
Yeah, I'm wrapping up a prior webinar I'm running right before it, and then I'll be jumping right on to that session and checking it out. So, well, that's it. Okay. That is our show for this week. As always, we want to say a big thank you to you, our loyal listeners, for spending your time with us, and ask you again, if you've got feedback, we hope you do. Leave it for us using the voice widget on the website at entertainmentlawupdate.com, or send us an email at entertainmentlawupdate@gmail.com. And how can folks find you, Tamera?
Yeah, you can find me online, most social media at Tamera Bennett, TamerABennett. You can find me at createprotect.com and also at harperbates.com.
And I'm Gordon Firemark. I'm in Los Angeles. My website, firemark.com. Email address, gfiremark@firemark.com. And gfiremark is how you find me on most social media sites. Let's give a big shout out to our crack team of volunteer contributors, which is dwindling. So listen up. Managing editor is John Janicek. We have Charles Thorne and Alexis Allen and Yuming Violet Zhang on the team. And we are looking for some new folks to join our little family of contributors. So if that's you and you're interested, reach out. The email address, once again, is entertainmentlawupdate@gmail.com. So with that, I will push the button for the music, which I have to get to. There it is. And we'll say thanks again. That's a wrap for this January 26th episode. Thanks again for listening.